trial by jury. The founders obviously believed that a jury trial was essential to preserving American liberty and justice. Today we often complain when we receive our jury summons in the mail. Many Americans believe that jury duty amounts to little more than a waste of time. Perhaps it is failure to understand the rights and powers of the American jury that more Americans don't take their civic duty more seriously. Jury nullification is a little-known right of the American juries that can play a large role in America's systems of checks and balances. Based on my research, I will present a brief outline on jury nullification. Jury nullification is the process by which juries refuse to convict a defendant in a criminal trial despite the belief that the defendant is guilty. I will first begin by giving a brief description of jury nullification. I will then describe the three most common types of nullification, and I will conclude with the impact of nullification on today's society. Jury nullification is a very controversial topic in today's judicial system. In exercising this right, the jury nullifies the law's effect on the defendant. In the Commonwealth Law Bulletin, Travis Reno expounds on the definition of jury nullification. According to Reno, in choosing to nullify the law, the jury refuses to be bound by the facts of the case or by the judge's instructions regarding the law. Jury nullification, then, is that one rare instance where a criminal jury can, in fact, extend its purview into the realm of the law without fear of legal redress. Jury nullification can never result in a guilty verdict. There are many reasons why juries choose nullification. In the Columbia Law Review, Ari Rubenstein describes the three most common types of jury nullification. They are classical, as applied, and symbolic. Classical nullification occurs when the jury believes that the law is unjust, or when the law is just, but the punishment is excessive. This might happen when a jury refuses to convict a defendant for a minor drug charge. As applied nullification is when the jury does not think the law is unjust, but in this particular instance it is unjustly applied. Refusing to convict campus protesters of trespass is one example of as applied nullification. In symbolic nullification, the jury does not believe that the law or its application is unjust, but they acquit for the purpose of sending a political message. Jury nullification can play a large role in America's systems of checks and balances. In the Harvard Law Review, Rachel Barco explains the impact of jury nullification on today's society. Most importantly, jury nullification can bring attention to systematic failures in the criminal justice process, which can lead to reforms in police procedures, criminal law, and the death penalty. Barco also suggests that jurors bring valuable perspective and individualization that may be lacking in criminal law. Arguably, the drafters of the written Constitution cannot anticipate and take into account every instance of a defendant's conduct and statically declare all unlawful and blameworthy. As you can see, jury nullification is an amazing power that is granted to the American people selected for jury duty. The Constitution gives Americans serving in the jury the right to judge the law based on their conscience and not just the facts. There are a number of reasons why jurors may decide nullification on a verdict. Repeat instances may even raise awareness to weaknesses in the written law and bring reform. Before I close, I just have one more thing I want to share with you. Some of you may be wondering why you've never heard of jury nullification. In 1895, in the Supreme Court case of Spark versus the United States, Justice John Marshall Harlan determined that trial judges had no responsibility to inform jurors of their rights to nullify laws. As a result, judges today typically do not inform juries about this right. It is therefore up to selected jurors to